The question is, can I be banned from driving even if I knew nothing about the court case? Well, the answer is yes. Courts frequently disqualify people from driving in their absence. And it might surprise you to know that if that person were then stopped driving, they would be guilty of the serious imprisonable offence of driving whilst disqualified, even if they didn't know anything about the ban. Now, the rule is that the police must serve the court paperwork, so that's usually a single justice procedure notice or a postal requisition, on the driver at their last known address. If that's done, then the court proceedings are perfectly valid, even if the person doesn't live there anymore. The court will then continue to use the same address. They'll send out notices and letters to that address. Provided everything has been done properly, then the disqualification will be perfectly valid. Let me give you a couple of examples of how that might happen, and then I'll tell you what can be done if it's happened to you. So the first example might be that the police pull a driver over, let's say for speeding or going through a red light. They'll take that driver's details, they'll have a look on the driving licence details, they'll take the date of birth, they'll take the address and all the particulars, and then the driver goes off on their way. Now that paperwork all then goes back to the police station, and then the police will normally issue the court proceedings a few weeks or months later, and they will be sent out to the address that was given at the time. Now, if that person has then moved, then the paperwork will still go out to the old address. So even if that person has updated their driving licence details and their car details, those details won't go back to the police, and so the police will normally serve the paperwork on the old address, and that means that the whole case will then be dealt with via that old address. And it's quite possible that the person, through no fault of their own, won't know that the court proceedings have gone ahead. Another example might be that a person has a vehicle registered to them, they've moved house, and they've forgotten to re-register the vehicle at the new address. This is quite common. People often remember to update their driving licence but forget to update the vehicle details. That vehicle then goes through an automatic speed camera. The police send a notice of intended prosecution, and they send it to the address which belongs to the vehicle, so the address on the V5. Now, if the person has moved and there's no way that they've had the post redirected, then they won't know that they've received the notice. Eventually, they will be prosecuted in the magistrates' court for failing to provide driver information. Of course, they won't know about those proceedings because all the letters are going to go out to the wrong address. They will be convicted in their absence, given 6 points. If they've already got points on their licence, that might add up to 12, and they could be disqualified from driving under the totting up scheme, where you get 12 points. So that's a second way that could happen. Now, if that's happened to you, or if it's happened to somebody you know, then there is some sort of redress. So what can happen is, once you find out about the disqualification, so that might be being pulled over by the police, it might be the fines bailiffs coming after you, it might be DVLA informing you that you're banned from driving, you can then make a statutory declaration to the magistrates' court, and that statutory declaration will cause the proceedings to reset all the way back to the beginning, and then you can enter your plea and deal with the case as normal. So that's the scheme. It's a statutory declaration. It technically has to be made within 21 days of when you find out about the incident, although courts do have some discretion to extend that in certain circumstances.